We are, Your Honor.
Okay.
I
Yes.
only see two of the panel on my screen, but I assume all three are there.
At least I'm seeing all three. David or Judge Weinsweig, can you say something just to make sure Mr. Bender can hear you?
Sure. Can you hear me?
I can, thank you.
Okay.
Yes, okay, and now I can even see you. Thank you.
Good. Yeah, it is. You know, things are less than perfect. But and let me look to my colleagues. We ready to proceed?
Ready.
All right, this is the time set for oral argument in Moonshadow versus IBN. Our case number is CV190790. Counsel, good morning. We are participating remotely versus Teams. The proceedings will be recorded, so please, as you begin your presentation, let us know your name and the party that you represent. If for some reason internet fails, if it fails for one of the judges, we're recording this and we'll listen to the recording. If it fails for one of you, we'll, sort of suspend the proceedings until we can get you back on. Let's hope that doesn't happen, but just to kind of ease your mind, if we can't hear you, we will let you know. And of course, if you're muted, we will let you know. We have conferenced the case. We're familiar with the record, and we'd encourage you to keep that in mind as you make your presentation. If appellant does wish to reserve a portion of your time for rebuttal, you're free to do so. You need to keep track of your own time, 20 minutes that you wish to allocate. And as I mentioned before we started, I will let you know if you do wish to reserve a portion of that time where you are after your initial presentation. So with that, Mr. Mandel, you may proceed.
Thank you, Your Honors, and good morning. May it please the court, my name is Robert Mandel. I'm with the law firm of Zuber, Lawler, and Del Duca, and we represent Moonshadow Properties. I think it's critical to appreciate that in the 2-year period preceding the February 06 conveyance to Moonshadow, the Med Center had become a vibrant and productive medical facility, just as it is today. It was approaching $10 million in value, providing healthcare services to thousands of Arizonans every month and jobs to hundreds of healthcare workers, all as it does today. It stood in sharp contrast with the vacant lot, which couldn't be developed, at least not without a cross-access easement, over the Med Center lot, which it did not have. And even then, development would be constrained to the 2,250 square foot building authorized in the recorded GFPD. I point out this disparity between the two lots at the time of conveyance for 3 reasons. The first is that unless the amended judgment is reversed, Masjid Omar will likely succeed in destroying the Med Center lot's value and productivity. The city can order cessation of occupancy. It can order citations for large financial sums that run with the land. The lender can deny refinancing the next time the owners need to refinance, which would mean a complete loss of their multi-million-dollar investment.
But counsel,
Yes.
Judge Weinsweig, I thought you were arguing an implied easement by prior use. Are you adding necessity?
No, Your Honor, the reason I'm pointing these out is that, as you know, comment H to the restatement 3rd, section 2.12 states or suggests that courts also factor into the implied intent analysis the economic repercussions of recognizing an easement. And I wanted to point out to the court that what the circumstances really were at conveyance and how that factors into the economic consequences of recognizing the easement that arose at the time of the conveyance.
But that's not one of the 3 elements, though, is it? Under coastal?
Correct. Costell, yes, Your Honor, it is not. It is part of the restatements approach, the most recent restatements approach to implied easements, and it does come up in this case, particularly because—
But there was a bench trial, right? I mean, go ahead, I'm sorry.
No, there was a bench trial, and in the course of the bench trial, the judge was made aware through testimony from the city's 30B6 witness that the servient lot is undevelopable. And so I pointed out because, firstly, not only because of the restatement comment that asks us to look at the economic consequences at the time of conveyance, but also because the whole idea that this will lead to the destruction of the value of my client's property is totally anathema to the prior use doctrine. I mean, that is actually a colossal understatement. The recognition of the easement over a servient lot is supposed to be equity's mechanism for averting grave consequences to the dominant lot when there's a documentation failure. Yes, I'm sorry, I didn't mean to interrupt, Judge Wyatt. So there's a bit of a delay.
No. I believe I understand.
Yeah.
I guess I'm having trouble with the posture of this case. Has it's come to us what the standard of review is. All right. So we had a jury trial, and aren't we? It's not a jury, a bench trial, and isn't our job to cull the record? And if there's can somebody mute? I can't.
Somebody's getting a call from Walgreens. That's what I can tell.
All right. So isn't it our objective to look in the evidence, and if there's reasonable evidence to support the court's conclusion, isn't that enough? Or is there some legal doctrine here? You have a case or a statute that says if you have financial ruin sort of on the horizon based upon that there's some other result possible?
Your Honor, let me try to break that question down, starting with the second question. It is my understanding, and I have read an awful lot of cases at this point, and I know you have too by reading the briefing and the secondary authorities, that the raison d'etre of the doctrine itself is to serve as a remedy in situations in which the grantee, after a documentation failure, like what happened in this case, to come to that grantee's rescue, and as importantly, to ensure, the reason to come to their rescue is to ensure that the dominant lot that they now own is not rendered valueless because of the failure to document the prior use. Because in many cases, including this one, without the prior use, the value, the utility, the productivity of the dominant lot, in this case, the Moonshadow Med Center lot, will be lost. That I think is a common theme that runs.
Well, is that? I mean, I don't want to nitpick, but is that accurate? I mean, it seems to me, aside from your client having the opportunity parcel, that there was also some dialogue at times with the mosque, and you just couldn't hammer out an agreement. Now, that seems a little different than sort of, the notion that an agreement is impossible. In fact, I thought there was some sort of sharing agreement in the past based upon when the lots were most frequented.
I don't think the question is whether an agreement was impossible. I think if we look at the doctrine and go to first principles, those that underlie the three-part test, what we're looking for is a way to infer what the intent of a reasonable grantor and grantee would have been had they known all there was to know at the time of the conveyance. I don't think that we're veering away from the doctrine, Your Honor, and you'll have to forgive me, but I guess I need you to, if you don't mind, to repeat your question, because I didn't quite follow it, and I really do want to be able to answer it.
Well, so how about I'll just go in I'll follow your question. Okay, sure. So let's say that this was an exercise in ascertaining intent.
Right.
And I think what we can both agree on here is that there was a bench trial with evidence and testimony, and Judge Kiley made findings of fact. And if he found, using what you had just framed the issue as a matter of intent, what is it in this record or what law allows us to effectively throw that out because there was also good evidence for your client?
No, Your Honor, this isn't just simply about a battle of the evidence as to each of his findings of fact. It goes much deeper than that. Judge Kiley didn't apply the doctrine correctly. The doctrine calls for the ascertainment of objective intent in the first instance by proving the three-part test. Otherwise, there would be no purpose for the three-part test. That is
well,
what
let's say
designed to do.
Are you saying that objective intent is dispositive? What if you have, let's assume objective intent, but you have absolutely no long and continued use? Isn't this a conjunctive three-part test? Or I mean, intent isn't even part of the three, but I know that it's often introduced with them. But the point is, if your client fails at any point on those three parts of the test, it doesn't prevail.
That's correct. But if they do prevail, if the test is applied correctly, which it was not here, because it was applied to the wrong theory of the case, and it incorporated facts from 5 to 9 years after the conveyance, if they do prevail on that, then they get the benefit of a finding that intent is reasonably implied and allocated to the parties. That never happened here. It is only at that point that the other side can come forward with evidence and try to overcome the, let's call it presumption plus, that arises from the three-part test, and try to demonstrate the existence of evidence showing contrary intent at the time of conveyance. That never happened here because the trial court divorced the concept of intent from the three-part test that's designed as a proxy to determine intent. That's why the entire first part of the written analysis is devoted to subjective intent. He never gets until the very end to the three-part test, and then applies it incorrectly to the wrong theory of the case. Our theory of the case wasn't about demand. It was about code compliance. And he relies on factors that he infers from events and communications that took place in 2011 and 2015.
Mr. Mandel, let me ask you about the post-conveyance evidence point that you make. Are you claiming, let's say the conveyance is January 1, year 1, and then there's some wildly significant event that happens the next day? Are you saying that would be irrelevant to, presumed intent or the three-prong inquiry or otherwise from the day before?
Well, Your Honor, that's a tough one, and that's your job, is to throw tough questions out there. I mean, none of the cases actually deal with circumstances where the evidence comes out the next day, and I don't know. I would say that a doctrinalist would say that under this doctrine, if you're looking for objective intent, you look at it up to the point that they signed whatever documentation effectuates the conveyance.
But isn't there another, body of law that, in terms of contract construction, and in some ways that's what we're talking about here, that pre-dispute statements or interpretation of the contract can have meaning as to what the contract actually means? Now, post-dispute, typically that's treated differently, but the fact that things happen before the dispute but years after the conveyance, I struggle with why the trial court could not consider those for any valid purpose.
Well, Your Honor, let me put it this way. There are two types of post-conveyance evidence that I think are worthy of thinking about here. Testimony of the actual grantor and grantee, which in fact rarely is a part of these cases, because often the case takes place long after they were part. They may not even be alive anymore. In those cases that are out there, though, where they are still around, where those folks are still around, the court will consider their testimony, but it's about their testimony is always about what their intent was at the time of the conveyance. juxtapose that, contrast it, if you will, with cases in which the opponent to the easement is trying to place in front of the court events or communications that happen years later. In all instances that I have been able to find, the court disregards that evidence because it considers it irrelevant to the doctrine. It does not even consider that evidence, by the way, when the opponent comes back and tries to refute the presumption with evidence of contrary intent, that is, intent that the easement will cease. And I think it's very important. I do want to emphasize that that is what contrary intent means under Costell, under the case Costell cites, and under the third restatement's approach as well. When they're talking about contrary intent, they're not talking about the absence of evidence of an intent for there to be an easement. That definition would simply swallow the rule about the inference of intent from the three-part test. What they are talking about, and if you dig into the cases, in those cases that actually adopt that approach, they are talking about contemporaneous evidence, usually in the form of an express statement by grantor and grantee, that the easement, the quasi-easement at that point, will cease to exist. And that is the narrow framework in which the rebuttal argument has to exist. In this case, and I think this is what the case comes down to, there is no evidence that satisfies that standard. Whereas we proved our claim, notwithstanding the judge's ruling and the findings of fact that the judge chose to focus upon. In our view, those findings of fact, I should say, are not just clearly erroneous because they were not supported by substantial evidence. As importantly, if not more importantly, most of them track a subjective intent analysis and ignore the three-part analysis. And in that respect, under Arizona law, they're clearly erroneous because they're induced by an erroneous interpretation of the law. And that's our point. Yes.
Counsel, let me ask you one question. Okay,
Please.
we'll try to break this down. So the third element is the use of the claimed easement must be essential to the beneficial enjoyment of the parcel to be benefited. So pretty simple question. If the trial judge does not find prong 3, your client loses, correct?
Well,
I don't want to go to the intent. I just want a yes or your client must prove essential to that the claimed easement is essential to the beneficial enjoyment of the parcel, correct?
Incorrect, Your Honor. Costell recognizes that the third element of the test in Arizona is reasonable necessity, not essential. And that is the majority rule throughout the United States. The three-part test that it recited at the outset was imported from a state that applies a strict necessity test to implied easements by prior use.
Okay.
Yeah. So,
that's fine.
To your point, yes. If you do not prove the third element, which I believe we did, you do not prove your case for an implied easement by prior use.
Okay, so let's focus on that and not sort of these larger concepts of intent. We have 3 specific prima facie elements, and one of them is, I think you said reasonable necessity. But let's agree on that. Let's say that's it.
Yeah.
If Judge Kiley heard the evidence and he found, and if you read his minute entry, he does find that the claimed easement it was not essential to the beneficial enjoyment for various reasons, including your client had the opportunity to buy the land or enter into a contract with the mosque. Or, I mean, again, what we're talking about here is an involuntary imposition of a property right and sort of tossing liberty interest to the wind. I mean, we need to understand what an easement is here. And so when we're looking at the word essential, go ahead.
Well, I was going to say that let us dispense with any notion that we're dealing with a bona fide purchaser without notice on the other side of this case. That party, Masjid Omar, knew all that there was to know about the restrictions on its lot before it purchased it. The evidence is clear and undisputed about that, and they don't assert bona fide purchaser. But let me get back to the point, which is Your Honor mentioned, asked to focus on the third element and to keep it away from the issue, to keep the discussion away or put aside the issue of intent. But that's impossible because the three-part test is designed to infer intent, and all three elements serve as the proxy by which to determine that intent. The judge found that the third test wasn't satisfied, but the judge applied the doctrine incorrectly because the doctrine required the judge not to focus on alternatives that were in existence in his mind incorrectly at the time of the trial, which are all of the ones that he focuses upon. If alternatives are to be considered at all, the existence of alternatives, they're to be considered at the time of the conveyance. And it's undisputed in this case that there were no truly viable alternatives to the APA, the parking lot on the vacant lot at the time of conveyance. Indeed, TDMC, the owner, had tried everything it could to come up with an alternative before it came up with that backup plan. It had filed, please.
Wasn't your client offered lot 2 as well? I mean, at the time of the transaction, what else could be more directly, we talk about life hacks. What's the hack here? Well, I think it's probably to buy lot 2.
Well, I suppose that could happen in every implied easement case, or in many of them. But in this case, if our client had known that it needed to buy the vacant lot in order to have continued use of the parking, I mean, given the de minimis price of the vacant lot that it was being offered for at the time as compared to a $9.4 million investment, they certainly would have. But they understood that they had continued the ability to continue using the APA on the vacant lot. And by the way, it's worth mentioning that so did everybody else, including the city. And if you apply the three-part test correctly, to try to determine what a reasonable grantor in Grantee, aware of all the circumstances there were to know at the time of conveyance, if you apply that test here, well, if the city experts in their own in the field of property thought that there was a continuing and perpetual right on the part of the dominant lot to use the servient parking lot in perpetuity, then why is it unreasonable that the grantor and grantee would have felt the same way? I mean, it's not easy, it's not hard to infer that intent and ascribe it to a reasonable grantor and grantee at the time of conveyance. And our client, as I mentioned before, and by the way, also the city and the grantor just happened to also testify throughout the case that it was their intent that the use would continue. To me,
Mr. Mandel, time goes fast.
Yes,
21 minutes and 45 seconds in. If you want to wrap up very briefly, and then with the indulgence of my colleagues, I'll give you 2 minutes in rebuttal, and we'll add additional corresponding time to appellee as well. But if you have just a brief wrap up and you're direct.
Your Honors, our point is simple, and let me wrap it up this way. We have a three-part test in Arizona, has not been overturned. The three-part test tells us whether or not the requisite intent has been proven. If you don't apply the three-part test in the first instance, you are already off the track. But then if you apply it to the wrong theory of the case and to the wrong set of facts, you're doomed. Here, the court applied its own analysis. Losing the word, but it applied its own subjective intent analysis in the first place, divorced it from the three-part test, and then applied the three-part test incorrectly, thereby denying our client the benefit of the presumption in the first instance that they had proven their implied easement. Thank you. Thank you.
Mr. Bedore, and you have 25 minutes to kind of equalize things, although, we'll see if you need that, but please proceed.
Thank you. Can you see me and hear me, everybody?
Yes.
Okay, thank you. May it please the court, my name is Josh Bendor, and I represent the Appali Masjid. I want to start where Mr. Mandel began and make clear that my client, Masjid, is not trying to destroy the value or productivity of the medical center. We did not bring this case. The medical center, Moonshadow, sued us. We had not taken any action against them before them. Moreover, there is no evidence in the record that would show that affirmance would destroy the value of the medical center. The city of Tempe hasn't taken any action against Moonshadow or threatened to do so. Moreover, Mr. Mandel's points show why the alternatives matter, right? And Judge Kiley found one of the reasons that Moonshadow did not need the easement is that it had many alternatives to taking away my client's property rights. And all of those alternatives existed just as much in 2006 as they did at the present or the time of trial. So it's a red herring to talk about when they existed. And I'm happy to talk about all those alternatives in detail, but I think the factual findings that Judge Kiley made there are ample. Mr. Mandel also wants to try to shift the burden from his client to mine, but ultimately the burden for a plaintiff seeking an implied easement is to show that it has met the test for an implied easement. And this court's decision in Porter says the evidence must be clear. And there's also ample authority, as we've explained, much for the reasons that Judge Weinsweig articulated, that the law disfavors implied easements. You should have to have a really strong reason to take away someone else's property rights through judicial fiat, and they don't have that here. One more quick point on what Mr. Mandel was saying. He says that the Masjid knew when it bought Lot 2 that there were basically 0 parking spaces available on that lot. And that's not what Judge Kiley found. To the contrary, Judge Kiley found that Masjid disputed what parking rights it had, and it believed that it had full rights to the lot and that none of those had been granted to the owner of Lot 1. The most important evidence, I believe, is that in 2006, during the negotiations over the sale of Lot 1, TDMC was selling Lot 1 to Moonshadow. TDMC made clear it did not want a one-sided parking easement. As a result, it's clear that the parties couldn't have impliedly agreed to one. Now, frankly, it doesn't matter whether you talk about that as objective intent or subjective intent. That distinction is a red herring because the negotiations are objective evidence, and any reasonable grantor or grantee knowing that evidence would say, yeah, if we talked about the issue, we couldn't come to an agreement, and TDMC was concerned about a one-sided easement. Obviously, they didn't impliedly agree to a one-sided easement. So, to go through it, Moonshadow's attorney, Mr. Lake, proposed a parking easement to TDMC's attorney, Victoria Longfellow. Longfellow was concerned it was one-sided. She told Lake she didn't think her client would accept a one-sided easement. Longfellow then emailed her client to warn him that Lake was not drafting the agreement as a reciprocal easement and that you need to be sure it doesn't mess up your parking rights. The next day, probably as a result of these conversations, Lake emailed Longfellow a proposed reciprocal easement, which would have created non-exclusive reciprocal easement for parking rights. That is, both lots could use the other's parking spots. But that's not what Moonshadow has sought in this case. It hasn't said, well, why don't we all just get along? You can use my parking, I'll use your parking. No, it has sought to take 41 of the 50 parking spaces on Masjid's land. Obviously, TDMC, which was going to be the entity retaining Lot 2 in 2006, didn't agree to anything like that. In fact, the parties at the time never executed the proposed reciprocal easement, but clearly given TDMC's pushback, it was not okay with a one-sided deal. The conduct in 2011 is also telling. That's when Masjid bought Lot 2. And at that time, the parties revived this reciprocal proposed easement from 2006, realized it had never been executed or recorded, and said, well, maybe we should do this. And they basically used the same document and just changed some of the names on it. And so that too would have allowed for reciprocal parking rights. There's no acknowledgement in that document, which is in the record, or in the parties' discussions about it, that there was a one-sided easement in effect. Because if that were true,
Counsel, let me ask you. I want to go to the second element and the use, the long and continued use. Judge Kiley seemed to he assessed and decided that elements based upon actual sort of physical use, meaning cars in lot 2, rather than what was a regulatory hurdle, and might also deserve the verb use, right? It's being used in a sense to comply with regulatory hurdles. Was Judge Kiley correct in that regard, that use in this context is cars parked on lot 2 rather than a regulatory blanket to protect your colleagues' clients?
Yes, he was correct. And first of all, the predominant theory at trial was the exact kind of actual physical use that Judge Kiley ruled on. But the problem with the zoning ordinance type of use that Moonshadow is now trying to rely on is that it's really not what the authorities talk about when they talk about implied easements. So if you look at the restatement, there are two kinds of discussed in the restatement. Access implied easements, can you traverse someone's land? And utilities, can you continue to bring power or water over someone's land? That is very different than the kind of use that Moonshadow is seeking here, because an access easement or having utility pole does not devour the value of the other person's land. By contrast, Moonshadow's claim, by their own admission, would devour the value of Lot 2, right? But Lot 2 has largely been used for parking during its lifetime, and they want to take over 80% of the parking spots on it. Now, Moonshadow cites several cases that they say support their zoning ordinance theory of use. But if you look closely at those cases, they don't really support it. So there's a Minnesota case they cite, which mentions a zoning use and dicta, and the case never actually talks about that. That's not what the case is about. There's another Minnesota case, same story. There's a Second Circuit case, O'Connell, that they talk about. That case does have a brief mention of code compliance, but it's in the context of figuring out what the parties intended at the time, what the parties' intent was in the context of this strange issue where you had unity of ownership questions. And that was the issue on appeal, because you had two different corporate entities, and there are questions of how did the relationship of ownership between those corporate entities affect the easement test. The Second Circuit on appeal was grappling with that issue in O'Connell. It was not at all deciding that going through the substantive test for an easement, you could actually grant someone an easement just to comply with a zoning use. And ultimately, the problem with zoning uses is they are very changeable. And yes, other things in the world can change too, but to some extent, there's no getting around that. And zoning uses are more changeable, I would submit, than the sorts of physical uses, right? There may be many, many years where a parcel is landlocked and there's only one way to get to it, and that's why you need an access, or there's only one way to get water to it. Those things are less likely to change than the number of parking spaces per square feet, which may change based on evolving technologies or global pandemics or patterns of transportation, all of those sorts of things. I do want to talk a little bit more about the alternatives that Moonshadow had in 2006. And to begin with, there's an argument that Moonshadow makes that you don't look at the alternatives at all. But I just don't think that makes sense, right? The question for an easement is whether there is a reasonable necessity to use the land. And if you have a ready alternative, you don't have a reasonable necessity to use the land. And the question is how ready the alternatives are. But you shouldn't be able to take someone else's property rights by judicial fiat if you have another easy solution. And that's what the law recognizes. That's what the restatement recognizes, and that's what the authorities that we cite in our briefing recognizes. And there were lots of different options available in 2006. One is the reciprocal parking agreement that the parties actually discussed, but apparently through a lack of diligence by TDMC and Moonshadow never agreed upon in 2006. Right? So if they had just actually inked that deal, we might not be here today. Well, my client shouldn't be blamed for that. My client shouldn't have its property rights taken away because of those parties' lack of diligence. Then there's a revised parking model, which would have shared parking between the Moonshadow lot and some other lot through a permanent arrangement. And there is currently in use today a revocable shared parking agreement between the lot where the mosque actually sits, which is north of the medical center lot and the medical center. There's no evidence that in 2006, at the time of severance, Moonshadow went to the mosque and said, can we make this agreement irrevocable? That would have solved its problem. My client shouldn't bear the burden for its failure to do so. They could have built a parking lot. The evidence shows they never carefully considered it. They just didn't, they kind of didn't want to spend the money. My client shouldn't bear the burden of that. They could have sought a variance in 2006. There is no evidence in 2006 that in 2006 or the preceding years, they filed a straightforward variance application to say, hey, we don't need as many spots as the code says. Can you give us a variance? They did that many years later after the bench trial in front of Judge Kiley, but they never did it around 2006 at the time of severance. Again, we shouldn't bear the burden of that. They could have sought to buy the land, as Judge Weinstein said, or they could have tried to rent parking spaces. The last thing I want to talk about before I get to the issue of fees is that an easement would virtually destroy the value of Lot 2. As the restatement explains, that shows the parties probably didn't intend it, right? So Lot 2 has largely been used for parking over the life of its lot. Moonshadow wants an exclusive right to use over 80% of the spaces. And that's very different than the kind of easements that the law generally recognizes. And now they've made some argument about how there's no value for the land anyways because vehicles can't turn around there. I think you've seen in the briefing why that wasn't properly presented at trial, why Judge Kiley all indicated quite clearly in the argument at the motion for new trial that their argument was waived because it hadn't been disclosed at all prior to trial. And in any case, even if there are problems getting things to turn around, that doesn't mean there's zero value to the land. It just means it's a problem you have to solve. There's no expert who testified and said, with that problem, the land has zero value. Unless the court has further questions on the merits, I will turn to the issue of fees. So there are two bases on which Judge Kiley awarded fees, both under 340-101. And Moonshadow had two theories of the case. One of their theories was the implied easement that we've been talking about today. And the case law from this court is clear that an action to enforce an easement arises out of contract. That's the Squaw Peak case that we cite. And ARS 12-340-101 is also clear that it applies equally to contracts that are express or implied. Thus, an action to enforce an implied easement arises out of contract in the same manner as an action to enforce an express easement. And here, Moonshadow claims that when TDMC sold Lot 1 in 2006, an implied part of that agreement was that Moonshadow could continue to park on Lot 2. That's what it's suing to enforce. That's the contractual right that this case arises from. And so this is a case arising out of contract. The other basis for fees is a claim that they haven't really pursued on appeal. But that claim is that the amended development plan created an easement by map or general plan. And so they sought to enforce rights under that third amended general plan. The leading Arizona Supreme Court case on implied easements by map or general plan is a case called O'Malley, which we cite in our briefs. And O'Malley says that's a contract claim. The reason is that there are rights created by the granting of the deed, and that the grantors and the grantees, even if they weren't in privity at the time, they have the rights and obligations that follow through to grantors and grantees, and that's what their other cases on restricted covenants explain. That's what they're suing under. Again, that's a contractual right, and Moonshadow can't really get around these facts. And in fact, below, Moonshadow never responded to the argument for fees under the map or general plan theory. They waived it. And on appeal in their opening brief, there's one paragraph responding to that. It's not going to cure their waiver. And in their reply brief, they never cite any of the cases regarding easements by map or general plan to explain why the decision below was incorrect. So I think the court can affirm on both of those bases for granting fees. At the end of the day, as Judge Whiteside said, this is a case with a bench trial. Judge Kiley saw the evidence, he heard the witnesses, he made credibility determinations. He determined, in a very detailed opinion, that Moonshadow had not met its burden to show any of the contested issues of fact, including the issue of intent, the issue of long and continued use, and the issue of reasonable necessity. He also found that the easement would destroy the economic value of Lot 2. None of those findings are clearly erroneous. They're all supported by the evidence. We would ask the court to affirm unless there are any questions. That is all I have for the court today.
Thank you, counsel. And I believe I left a consonant out of your name when I introduced you, Mr. Benner. I apologize. Mr. Mandel, 2 minutes in rebuttal.
Okay, let me try to compress my responses to 2 minutes. First of all,
I'm sorry. I hear like 3 voices.
Yeah, there is a little echo. Let's all mute if we're not speaking. So, Mr. Mandel.
Is it still that way? Okay, can you all hear me now? Okay, let's start the 2 minutes now then, please. Alternatives. Opposing counsel tries to buttress the court's decision finding that alternatives existed at the time of trial, totally outside the relevant scope of inquiry, and those alternatives did not exist at the time of the conveyance either. The reciprocal agreement, as we brief in our opening brief, would not have achieved what the city requires in terms of an irrevocable right to use the 41 spaces. The shared parking agreements were all revocable. The only property that had enough spots to meet to make up for the deficit that Moonshadow had was the church lot. The church lot would not enter into an irrevocable agreement. It was attempted, it failed, and that never changed. That was not an alternative either. Building a parking lot, well, the test is whether it's reasonably necessary for the convenient enjoyment of the property. Building a parking deck would have required closing a fully occupied facility, stopping services for months, if not years, and all the expense associated with it. That's not a realistic opportunity. There are no cases that would require a party to go through that kind of effort to come up with an alternative to something that the city had already blessed and in a recorded document as the appropriate solution to the parking deficit. The variance is almost folly at this point. We were told by the city not to bother seeking a variance because we had the GFPD and the parking solution. It was only after to the astonishment of the city and all the parties that we sought the variance because of the judge's decision. And when we sought it, the other side opposed the variance, though it had no impact whatsoever on their property. And they successfully appealed the conditional variance to the Superior Court, which vacated the variance. So that's totally out as well. The one-sided agreement is also a red herring. The record reveals that whatever that document was, Attorney Longfellow, who was the only witness to testify about it, didn't have it, never read it, merely speculated about its content. It's not in the record. There's no evidence that she rejected it, that she had authority to reject it, that she recommended that TDMC reject it, or that she received any response from anyone at TDMC that to her concerns about it. There's no evidence that TDMC ever rejected it. In fact, the opposite. and she knew nothing about the GFPD or the parking solution, so she wouldn't have understood what the import was anyway of an easement. Totally red herring, nothing approaching the kind of subjective intent evidence that the cases actually require if you're going to try to repudiate the presumption of an implied intent that comes from the three-part test.
Mr. Mandel, time does
yes.
go fast. If you
Yes,
have another 15 seconds, we'll afford you that courtesy.
Surely. There was no waiver of the argument regarding the attorney's fees on the GFPD theory. It was argued ad nauseum at oral argument beginning at page 9. The transcript of that argument is in the court's, is in the docket. And we also argued it, we preserved it well enough in our opening brief and then went into it quite extensively in our reply, where we explained that we weren't arguing a contractual GFPD theory. Our argument was always an estoppel and notice theory in the nature of the Shalimar case. Thank you, Your Honor.
Counsel, thank you. Thank you for your briefing. Thank you for your presentation today. We will take the matter under advisement. We'll issue a written ruling in due course. Court is adjourned. Take good care.
Thank you.